SJC-13058, Town of Norton v. Annabella, Pesa, and others.
Okay, Attorney Weissite.
Thank you. Good morning, Madam Chief Justice, Justices, brother counsel. May it please the court. Alex Weissite from KP Law on behalf of the appellant, Town of Norton Conservation Commission. It is an honor to stand before you today to advocate on behalf of a cause in which I believe strongly, and that is the preservation and protection of the Commonwealth's wetland resource areas and the authority of local conservation commissions to protect such resource areas and the public values created by such resource areas. My argument today will focus on three principal reasons why this court should reverse the judgment that was entered by the Bristol County Superior Court, which dismissed the commission's complaint seeking injunctive relief, compelling compliance with the enforcement order issued by the commission, which would require the defendants to remove approximately 13,000 square feet of fill material, which was unlawfully placed in wetland resource areas on the defendant's property at 162 West Main Street in the town of Norton prior to their purchase of the property. As an initial matter, the Superior Court erred in entertaining substantive arguments attacking the validity of the commission's enforcement order because the defendants failed to exhaust their administrative remedies by filing a timely certiorari appeal of the enforcement order pursuant to General Law, Chapter 249, Section 4. However, regardless of this argument, I would move on to address the substantive merits of the court's interpretation of paragraph 30 of the Wetland Protection Act.
I think as your initial point, talking about the importance of protecting wetlands, and certainly is, we have a statute of limitations as it relates to continuing violations that never go away. And I think I'm not sure I agree with it, quite frankly, but I think what Judge McGuire was doing was saying that if we're going to have continuing violations, for the statute of repose to mean anything, we have to say it's limited to the first transfer. I think that's really the core of what he's trying to say in order for it to be implemented. What's your response to that?
Agreed, Your Honor, and I would respectfully disagree with that interpretation because in looking at the plain language of paragraph 30, the paragraph provision references not only the transfer of the property, but also refers to what type of violation you're dealing with. So not only is it, I would argue that we're dealing, yes, it's a statute of repose in the sense that the transfer of the property may trigger the protection and the time bar associated. However, you also need to look at what type of violation you're dealing with because other provisions in the Act, particularly paragraph 32, reference leaving fill in place as an ongoing violation.
And so, also, I know that the defendants argue differently, but isn't there an issue about how the legislation was initially proposed that specifically said that it was for the first transfer, and that didn't pass? Yes,
Your Honor. So I agree. The legislative history here is very important for this court to review. In 1975, paragraph 30 of the Act was enacted in a bill that was entitled, the bill was entitled An Act Relative to the Enforcement of Violations of the Wetlands Law Against Subsequent Owners of Real Property. And the use of plural there in the title, I think, is important because we're not talking about just the initial transfer. We're talking about all subsequent owners. And moreover, Your Honor, the alternative bill that was rejected by the legislature in 1975 rejected language that would, in my opinion, have been more consistent with the Superior Court's decision here. And that language would have limited the application to the first person to acquire the property. And instead, the legislature chose to apply language saying any person who purchases or inherits, not simply the first.
The defendants make a good point, though, when they say, well, the bottom line of all this is the wrongdoer is free off after 3 years. They put the fill on and left it there. And then you got some innocent person who's just buying the property. They didn't cause the problem. And there you go. They're available to have an enforcement action. And that doesn't seem quite right.
Well, respectfully, Your Honor, I would not agree that the purchasers here were innocent. In fact, they were well aware of the violation before they purchased
Yeah,
it.
you've got a good point on the facts here. I understand with what happened, but
Is the original wrongdoer off the hook, or is only the first purchaser, the purchaser is off the hook after 3 years, but is the original wrongdoer who doesn't sell the land ever off the hook?
Well, Your Honor, the original wrongdoer here is deceased.
No, I'm talking about the way the statute works. If you don't sell the property, you don't have protections on the statute of repose, right? You're still liable. It's
Correct.
What happens is when we deal with the purchasers of the property, then they can get a 3-year protection, right? But the original wrongdoer, the guy who put the fill in, if they're still alive and they still own the property, they have the problem forever, right?
Absolutely, Your Honor, that's correct. And I think that gets to one of our main points as well, which is the interpretation that the Superior Court has offered would leave a hole here in the statute, in that a developer could conceivably buy a piece of property, fill in a wetland, transfer the property to a different entity. That entity could then wait 3 years and the entity would be absolved of any liability.
Can you help me? I'm sorry, are you done, Justice Kafker?
No, go ahead, Justice Gaziano.
Thank you. Can you help me with the dividing line between one-time violations and continuing violations? Here, I think it's fairly clear because we have clear-cut vegetation, so one time and in the fill is ongoing.
Correct.
But given the fragility of wetlands, something you open with, aren't a lot of violations going to be ongoing? So for example, if I build a shed that encroaches too close to wetlands, it's a violation when I build it, but is it an ongoing violation past that? So how do we define that in our case law?
That's a good question. Thank you, Your Honor. I would agree there is a dividing line here. In the case law, references leaving fill in place specifically as an ongoing violation because of the harm that it causes going forward. I think as an initial matter, it's up to the local commission in the first instance to make a determination as to how the harm, whether the activity or alteration is a harm that can be remediated on its own, or does there need to be some type of work that's ordered to deal with the ongoing impact.
Right. So, and here the example is fairly clear, but how do we define that when we write the case?
Your Honor, I would ask that you leave that to the commission to determine in their discretion as to.
So we say that here there's a one-time violation, and then there's a continuing violation, and it's case by case.
Yes, Your Honor. I think it's best to leave it to the commission in the first instance to determine what the violation is, what the impacts are that will result from that violation, and what the best way to remediate that violation is.
But
And
what does that
perhaps
do?
the AG can weigh in on that as well.
Yes,
Thank you.
Just ask you a follow-up question to Justice Gaziano's question. Does that mean that the commission can determine that this vegetation issue in this case is an ongoing violation? Or is that statute of limitations run?
Your Honor, I believe that the statute of limitations would not have run because of the discovery rule. The commission did not actually learn of this violation until the Pesas came to the commission after doing their due diligence, and the conservation agent went to the property and realized that there was clear cutting. So the 2 years would have run, I think, when the commission through its agent first learned of the violation.
And is that the discovery rule that's applicable? It's not should have known, but actually did know?
Yes, Your Honor.
And why is that?
Because there's the scheme that's set forth here, in particular to this case. When you have an order of conditions that's recorded against the property that allows a certain project to go forward,
It's not until the applicant asks for a final
certificate of compliance that then triggers the conservation agent to go look at the property and determine, whether or not there was compliance. Here, the agent did that and noticed that there was an excessive amount of fill beyond the limits of what was allowed in the permit. And that, I think, gets to one of the overall arguments you make as well about the goal of finality. Here, the goal of finality is only achieved by compliance with the commission's enforcement order and bringing the property into compliance with the order that was recorded in the registry. That order will never be released with a certificate of compliance until the property is brought into compliance with the order of conditions.
Okay, does anyone have any further questions? Okay, thank you.
Thank you, Madam Chief Justice. Thank you all.
Okay, Attorney Frankel.
Thank you. Good morning, Your Honors, and may it please the court. David Frankel on behalf of the Commonwealth. To strike a balance between the rights of long-term owners on the one hand and the rights of the public on the other hand in functioning, healthy wetlands, the legislature enacted a time bar whose sole effect is to create a 3-year window in which to sue any new owner who acquires property with pre-existing wetlands violations. And that window runs from that owner's date of acquisition. First, I'll just start with the plain text, which is dispositive here. Under the Act, such person is entitled to freedom from suit if 3 years have passed since the property was acquired by such person. In using the such person phrase twice to specify the individual entitled to repose and also the individual whose property acquisition triggers the clock, the statute is susceptible to a single meaning, and that's that a particular owner's right to repose is triggered by the date of that particular owner's acquisition of property.
Mr. Frankel, the defendant argues just the opposite and says that since the statute doesn't say it renews with every transfer, they come up with a different plain meaning argument.
So first, that interpretation is inconsistent with the such person twice repeated language in the statute. But even if there was any doubt on that score, the legislative history here is crystal clear. So the legislature twice rejected broader protections from suit. In 1974, the legislature declined to advance a bill that would have provided a universal right to repose running from the date of the illegal work. And the legislature again in 1975, before it enacted the bill with this language, explicitly considered and rejected a bill that would have granted repose to all owners 3 years from the date of the first transfer. And so the defendants in this case are trying to avail themselves of essentially that statute that the legislature declined to enact, and accepting that argument replaces the bill that a legislature did in fact enact with one that it declined to.
Is the defendant wrong that their interpretation of the statute of repose is consistent with DEP's regulatory interpretation of the statute and their regulations?
No, that's incorrect. And even the documents they cite, the guidance documents from DEP has maintained this interpretation historically and maintains this interpretation currently. There is one case they cite, the Veeder case, that goes into this a little bit, on which I think the defendants rely. And that case is actually just a strange case that takes a position that no one agrees with, in which the statute of repose runs 3 years from the date of an enforcement order. That is an odd case in a different context, and no party here, defendant, plaintiff, or the Commonwealth, thinks that is the correct approach here. I mean, I'd also come back to...
It's a little odd, and I thought your brief was excellent in sort of explaining the history and the language. It is a little strange that we have a statute of repose that really doesn't provide any repose. It provides sort of an individual repose, but it doesn't do much, right?
Yeah, so I'll acknowledge that this is a somewhat unusual statutory scheme, but fundamentally, I think the important question is not so much which bucket this time bar fits into, whether it's a statute of repose, whether it's a statute of limitations, but fundamentally the question is, what was the legislature trying to do when it enacted this language And here we
Well,
have
and
the
that,
plain
and that
text.
goes to my question, counsel, which is what best protects the land? What version, what interpretation best protects the land?
Well, our interpretation, Your Honor, is the one that best protects the land here. I mean,
Because
as we've discussed,
But yours, I mean, to a certain extent, that's true, but I mean, if you never sell if you sell the land to one person, the first buyer, Mrs. Pesa, whatever her name was, she, 3 years from now, if she doesn't sell it, that land can never have to be remediated, right? It's not, the legislature didn't adopt the most protective version, the greenest version here. They sort of did a compromise. The conveyancers wanted to clean up title. The environmental people wanted to clean up the wetlands, and the legislature sort of created a clever compromise that requires cleanup after sales, right?
yes, that's true. I would entirely agree that what this statute does is it reflects a compromise between a different set of competing interests. I mean, on the one hand, the Act's fundamental purpose is preserving and restoring wetlands, and the Act accommodates that by ensuring that unlawfully destroyed wetlands are not forever taken out of the Commonwealth's ability to correct and restore. But the legislature did recognize that certain long-term owners are going to have some interest in their property, some settled expectations, and the statute does.
Every long-term owner, except for the original bad doer, every long-term owner will have protection after 3 years, right? Every purchaser. So, I mean, it's clever what they did, but it's not the greenest approach. It's a compromise.
No, that's right. I mean, it is a middle ground. I mean, there could be no statute of repose at all, which in fact would be more consistent with the wealth of environmental remediation statutes that are out there. If there is hazardous waste on your property, your obligation as the current owner of the property is to remediate that no matter how old it is. And so what this statute does is it affords actually additional protections for long-term owners that are not typical in most environmental statutes and accommodates the interest. And there's certainly, the legislature could have gone further and had ongoing violations not be subject to the statute of repose at all. That's certainly one thing they could have done. They could have, as enacted, the Wetlands Protection Act didn't include any type of protection at all. And so they do go some way away from the most possible protective approach here.
Can you answer the question about defining ongoing versus one-time violations and how we're supposed to do that?
Yes, our view on that, Your Honor, would be that in any circumstance where there is a violation that has some continuing effect, that it would be an ongoing violation. So fill in place would be an obvious one. In this case, the record suggests.
Doesn't clear cut and vegetation have an ongoing effect too?
Well, I think that really is a factual question. And so in this case, there's no evidence that clearing of vegetation, that it didn't grow back to go back into its natural form. But if vegetation was cleared, I mean, if there was a swath of wetlands that was cut down and replaced with a lawn, I mean, that would be an example of an ongoing violation subject to the same rules that we talk about here.
Is there
really
no regulations that provide guidance on this? We're just going to leave this to the commission to sort of sort out that there isn't a regulatory explanation of what's an ongoing and what's a one-timer?
Yeah, I mean,
Well, what I'll say to that is the statute talks about restoring property to its original condition.
I mean, your example is I mow down the wildflowers with my John Deere, and then 3 months later they grow back. That's well and good, but suppose they don't grow back. So we're going to have the vagaries of whether they grow back to be an ongoing versus a one-time violation.
Well, I wouldn't say it's the vagaries, but in some sense that is correct. I mean, the statute, I turn to the statutory language here because the statute talks in several places about the original condition of the property. So the statute itself gives the guidance on this score, which is, did whatever action occurred change the property from its original condition, and has it reverted to its original condition, or is there some ongoing effect? And if the latter, then you have the type of ongoing violation that's subject to the restoration remedy, and that subsequent owners would be responsible to correct, assuming that the statute of repose hasn't been triggered.
Okay, thank you.
Thank you.
Attorney Nagel.
Thank you, Chief Justice Budd, and good morning, justices. May it please the court. Paragraph 30 is a statute of repose, not a limitation, and there's three reasons for that. One is the language creates an absolute bar to liability after 3 years. Secondly, it runs from the transfer of the property rather than when the cause of action arises. And thirdly, the Wetlands Protection Act already has a statute of limitations under Section 91, and that's a 2-year statute.
Mr. Nagel, all of those arguments may be right and you may win. I do not understand your position that the position of the town and the Attorney General's position is frivolous and you should receive costs and fees, considering, I'm not going to list everything, the title of the statute, the intent of the Wetlands Act, the nature of the ongoing violation, the safe harbor, and a multiplicity of other reasons. You may win, I don't know, but how you can say that the position of the AG in the town here is frivolous and you should receive costs, I just don't understand that.
Yes, I think one of the, I agree that the Commonwealth's brief is excellent, but one thing that I think I'd like to point out about it, this statute, like many of the statutes that the Attorney General's office points out, are remedial, strict liability statutes. This really isn't, except for this paragraph 30. This statute is a causation statute. It begins by saying any person who alters wetlands, so it's causation. The one exception is paragraph 30, where it says that an innocent purchaser is liable, even if they had nothing to do with it. And so in 1975, they amended that provision to say, well, wait a minute, these innocent purchasers, we're going to give them three years to clean up the alteration that was performed by a prior owner.
But why is
But
it
after 3 years,
unreasonable?
then they're
Counsel,
done.
why is it unreasonable to read the statute to give these, quote, innocent owners 3 years each?
Because it results in, Your Honor, it results in an absurd result where every 3 years, the liability springs up again. So
No,
what you can have
it
is a
springs up
situation
with
where-
it springs up with every purchase or inheritance. So not every
Exactly.
3 years, it's every time the property turns over, there's a 3-year window where the commission gets another bite at the apple. Why is that unreasonable?
Because it goes against the whole nature of statute of repose.
Well, it definitely is a unique statute of repose, I'll grant you that. But why wouldn't that be consistent with the intent of the statute to overall protect the wetlands?
Because the overwhelming majority of enforcement cases, most of the statute addresses the regulatory process of getting a permit to do work in wetlands. With regard to enforcement, most enforcement is done when somebody alters wetlands, when a current landowner alters wetlands. If they alter wetlands without an order of conditions or a permit, then enforcement ensues. Or if they don't comply with the order of conditions, then enforcement ensues. Very rarely, if ever, does the Commonwealth or the commissions go after an innocent landowner for violations
But you say, I
done
don't,
by somebody long ago.
so excuse me to cut you off, but
Sure, sure.
when you say innocent landowner, isn't this on a cloud on title? Isn't that how the Pesas learned about this? They did a title search. They learned, oh, wait, there was no final order here. Let's see why. So when they bought the land, they were on notice that this was a problem with the land, that it had never been closed out. Why is that? Why is it unreasonable, given the notice that they had prior to the purchase, to read the statute in the way that the AG would like us to read it?
Well, the statute says what it says, and the statute says that for a subsequent owner, they have liability for 3 years, then that liability is cut off. And
Right, but I
That's
guess you're
none of-
missing the point. Why isn't it the next subsequent owner also have a 3-year window?
I'm sorry?
Why is it unreasonable to give the next subsequent owner another 3-year window?
Because you can have a situation where a subsequent owner, where you can have a situation where an owner owns the property's transferred, they own it for more than 3 years, their liability goes away. And then they sell that property to somebody else. The purchaser acquires liability that the prior owner didn't have. That just doesn't make sense. And the idea is to make sense of a statutory provision. And to the extent that there's any ambiguity,
I know, but
and obviously
it's
we're talking about an
strange,
ambiguity.
it's a strange compromise, though. There's nothing about privity in this statute. It's an odd statute of repose, but there's a clear desire not to let anyone off the hook, at least for 3 years. I don't find it that hard to figure out what the legislature was intending here. They didn't do what you wanted, which was give clear title. They rejected that statute. They passed this statute, which basically prevents, profiting off of not cleaning up the fill in certain ways. I mean,
Right. I mean, the original provision before 1975 said that when the property transfers, there's liability forever. But in 1975, they passed this amendment that said that, wait a minute, we're going to put a 3-year time limit on that liability.
But just
And it
as
didn't say
Kafka,
it's
just
gonna
as
recur.
Kafka, just as, I know it's hard to find us, I apologize.
I'm sorry.
Just as Kafka points out, though, that the legislature rejected application only to the first transfer of property. And instead, what they say is any person who purchases, inherits, or otherwise acquires real estate.
Right. There's no legislative history that actually explains why that language did not see its way to final passage. But if anything, we can explain it through grammatical consistency, that such party and such person, as opposed to the language that was in House Bill 655. And when there is that ambiguity, the legislative history doesn't say why that was changed. So all we're left with is the language that's in the statute.
Council,
The language in the statute
can I go
does
back
not
to
say
some,
recurring liability.
Council, could I go just back to Justice Wendland's point? Because I'm still struggling with this, and I'd like you to tell me why it doesn't make sense to continue with another 3 years for any subsequent person who acquires this land. And it fits with what happened here. If you are in the position where, let's say, the original owner who was on the hook for 3 years, it's now year 5, and the current record title owner has no liability under the statute, and then they transfer out, like in this case, and your point was, it doesn't make sense that you're getting something more than the owner has, which is the liability. Why doesn't it? Because just like in this case, the subsequent purchaser has to do their due diligence. And they might find out what your clients found out. And then they have an opportunity to enter into that transaction with eyes wide open, that there's this issue, and if you are buying at risk. Why doesn't that make sense? Because they can walk away.
Well,
And then you achieve the purposes of the statute in the sense that the owner who now is perhaps outside of the statute of limitations has a real Hobson's choice. If I ever want to unload this property, I got to fix this, whether I've got a statute of limitations or not, because I'm never going to be able to transfer it because they're always going to run when they find this issue. Why doesn't that make sense?
well, what does make sense, and part of what you said, I think, does resonate, in that if there's an owner that actually altered the wetlands illegally and then transfers it, they know that transfer is subject to the due diligence of the purchaser, and they're going to find out that there's an alteration, and that new owner is going to have liability. But the statute says, for only 3 years. And so what doesn't make sense is after that due diligence and the purchaser can either decide to acquire or not, or negotiate to make sure that just like in Title V, to get the septic system fixed, to get the wetlands fixed before the purchase. But regardless, when that transfer happens, that new owner has liability. And that makes sense. And in 1975, they said, well, wait a minute, that really is a problem with transfers, multiple transfers of properties over long periods of time. And they put a 3-year limit on that. So what really doesn't make sense when you go forward, transfer after transfer, is you can have an ancient violation that memories fade, people pass away, documents are lost, and decades later, you'll have an innocent purchaser who acquires property where there's a violation and they had no idea that there was a violation there. So
Yeah,
the
but
legislature.
the problem is we also have a wetlands violation. And, wetlands are important environmentally, and we want them cleaned up. And under your approach, there's absolutely no incentive for anyone to do so. And it's hard to imagine that that's what the legislature intended, to let everyone off the hook, going forever and ever, as opposed to, okay, DEP has to get, or the Conservation Commission has to get its act together within 3 years for each purchaser, or we move on to the next person. But your approach just is very damaging environmentally, and that's what the conveyancers want, but that doesn't seem to be what the legislature did.
Well, I don't mean to repeat myself, but in terms of environmental damage, and I understand the Commonwealth's point here, is that obviously the Wetlands Act is to protect the wetlands, but the overwhelming majority of cases in which wetlands are protected.
I find that statement totally unfounded, that DEP only goes, everyone goes away after the initial person doesn't do the cleanup. They're monitoring, and as soon as they learn something's out of compliance, they're unhappy. What basis do you have for saying that in the overwhelming majority of cases? Is there anything in the record that supports that statement?
Well, there's no reported cases that I'm aware of, Your Honor, that addresses this very issue of the statute of repose. And I think there's a reason for that.
Statute of repose, but the issue of whether DEP and the conservation commissions, when they learn about an old violation, just go away. That's news to me.
What they learn about is when there's active alteration of wetlands, and whether that's done in compliance with an order of conditions or in violation of it. And when they do
explain that, counsel, because I thought I read in one of the briefs that in fact they don't continuously monitor these ongoing projects, and they wait until there's a request for a final approval to come in and inspect the land. Is that, are you arguing that that's just not true? What do you?
No, I'm not, Your Honor. There is a mechanism, and again, this is more of a regulatory program rather than a remedial program, like a lot of the statutes that were cited by the Commonwealth. But there is a mechanism, it's called the Certificate of Compliance. And that is related to the permit that's issued to allow people to work within wetlands under certain conditions. And it's a 3-year permit. And within those 3 years, the permittee is required to go back and request from the Conservation Commission a certificate of compliance to ensure that whatever work was done within wetlands jurisdiction, it was done according to the conditions of the permit. And so this statute is overwhelmingly a way to allow people to work within wetlands jurisdiction, provided they do it in such a way that doesn't harm the wetlands. What we're talking about here are ancient violations that were not detected by the state or by the commissions. And so what do you do with those ancient violations? Well, if property is transferred with those ancient violations, the new owner is in fact liable The statute said the new owner is liable forever, but the amendment says they're only liable for 3 years. And and that's clearly a statute of repose. So to have that 3-year liability pop up and then the liability go away, and then for it to pop up again over and over again, where a innocent owner acquires property and acquires liability that wasn't held by the seller, just doesn't make sense. And to interpret this provision in a way that doesn't make sense is I would suggest, is not the proper interpretation of the statute.
Okay, thank you very much.
Thank you.